Hello and welcome to Bar10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. Don't forget to like, subscribe, and click the notification bell so you can be updated every time we upload new content. It's our goal to upload new content every day at 8 a.m. Eastern Standard Time. We look forward to seeing you. Let's start with question number 1. The open-air amphitheater in the city park of Wrightville has been utilized for concerts and other entertainment programs. Until this year, each of the groups performing in that city facility was allowed to make its own arrangements for sound equipment and sound technicians. After recurring complaints from occupants of residential buildings adjacent to the city park about intrusive noise from some performances held in the amphitheater, the Wrightville City Council passed an ordinance establishing city control over all sound amplification at all programs held there. The ordinance provided that Wrightville's Department of Parks would be the sole provider in the amphitheater of sound amplification equipment and of the technicians to operate the equipment to ensure a proper balance between the quality of sound at such performances and the respect for the privacy of nearby residential neighbors. Which of the following standards should a court use to determine the constitutionality of this content-neutral ordinance? A. The ordinance is narrowly tailored to serve a substantial government interest and does not unreasonably limit alternative avenues of expression. B. The ordinance is rationally related to a legitimate government interest and does not unreasonably limit alternative avenues of expression. C. The ordinance is rationally related to a legitimate government interest and restricts the expressive rights involved no more than is reasonable under the circumstances. Or D. The ordinance is substantially related to a legitimate governmental interest and restricts the expressive rights involved no more than is reasonable in light of the surrounding circumstances. Take 10 seconds and choose the best option now. If you chose option A, you'd be correct. The ordinance is narrowly tailored to serve a substantial governmental interest and does not unreasonably limit the alternative avenues of expression. For content-neutral restrictions to be valid, the restrictions must be substantially related to an important governmental purpose. Content-neutral regulations are laws that regulate the time, place, or manner of all speech regardless of the speech's content. The extent of permissible government regulations on content-neutral speech depends on the forum where the speech is taking place. In a public forum, such as a park, the content-neutral regulation must serve an important government interest, such as noise control. The regulation must be narrowly tailored to that governmental interest, and the regulation must leave open alternative channels of communication. In this case, the Wrightville City Council passed a content-neutral ordinance to regulate the noise from amphitheater performances. The ordinance is content-neutral, so it is subject to intermediate scrutiny. This means the ordinance must serve an important government interest. The ordinance must be narrowly tailored to that government interest, and the ordinance must leave alternative channels of communication. As such, A provides the correct standard that a court should use to determine the constitutionality of such an ordinance. Question number 2. Doe negligently caused a fire in his house, and the house burned to the ground. As a result, the sun streamed into Peter's yard next door, which previously had been shaded by Doe's house. The sunshine destroyed some delicate and valuable trees in Peter's yard that could grow only in the shade. Peter has brought a negligence action against Doe for the loss of Peter's trees. Doe has moved to dismiss the complaint. The best argument in support of this motion would be that A. Doe's negligence was not the active cause of the loss of Peter's trees. B. Doe's duty to avoid the risk created by a fire did not encompass the risk that sunshine would damage Peter's trees. C. The loss of the trees was not a natural and probable consequence of Doe's negligence. Or D. Peter suffered a purely economic loss, which is not compensable in a negligence action. Take 10 seconds. If you chose option B, you'd be correct. Doe's duty to avoid the risks created by a fire did not encompass the risk that sunshine would damage Peter's trees. To establish a prima facie case of negligence, the plaintiff must show a duty a breach of that duty, causation, and damages. However, there's no duty owed to unforeseeable victims. In this case, Doe negligently caused a fire in his house and burned it down. While Doe had a duty of reasonable care to not burn down his house, this duty only runs to foreseeable victims. Since sun damages to trees is not a foreseeable injury of a burning down house, Doe owed no duty to Peter, so this would be his best argument in support of his motion to dismiss this case. Question number 3. Devlin was charged with murder. Several witnesses testified that the crime was committed by a person of Devlin's general description who walked with a severe limp. Devlin, in fact, walks with a severe limp. He objected to a prosecution request that the court order him to walk across the courtroom in order to display his limp to the jury to assist it in determining whether Devlin was the person that the eyewitness had seen. Devlin's objection will most likely be A. Sustained, because the order sought by the prosecution would violate Devlin's privilege against self-incrimination. B. Sustained, because the order sought by the prosecution would constitute an illegal search and seizure. C. Denied, because the order sought by the prosecution is a legitimate part of a proper courtroom identification process. Or D. Denied, because a criminal defendant has no legitimate expectation of privacy. Take 10 seconds. Correct answer is denied because the order sought by the prosecution is a legitimate part of a proper courtroom identification process. The police and prosecution may use different methods wherein witnesses can identify a suspect as the perpetrator of the crime. These methods include photo identification, lineups, and in-court identifications. The identification process must be fair to the suspect, not involve prejudice, and therefore not violate the defendant's due process rights. In this case, several witnesses have identified that the suspect walked with a severe limp, so it is entirely proper for the prosecution to request that the court order Devlin to walk across the courtroom. As such, Devlin's objection should be denied. Question number 4. Under the terms of a written contract, Karp agreed to construct for Manor a garage for $10,000. Nothing was said in the parties' negotiations or in the contract about progress payments during the course of the work. For this question only, assume the following facts. After completing 25% of the garage strictly according to Manor's specifications, Karp demanded payment of $2,000 as a reasonable progress payment. Manor refused, and Karp abandoned the job. If each party sues for breach of contract, which of the following will the court decide? A. Both parties are in breach, and each is entitled to damages, if any, from the other. B. Only Karp is in breach and liable for Manor's damages, if any. C. Manor is in breach and liable for Karp's damages, if any. Or D. Both parties took reasonable positions and neither is in breach. Take 10 seconds and choose what you believe to be the best answer now. If you chose option B, only Karp is in breach and liable for Manor's damages, if any, you'd be correct. A breach of contract occurs when a party to the contract does not perform after performance comes due. Therefore, if performance has not come due, there cannot be a breach. Likewise, if the party substantially performs his obligations under the contract, there is no breach. Performance only comes due after the occurrence of all conditions precedent to performance. A material breach is a refusal to perform under the contract that goes to the heart of the promised performance. The non-breaching party does not receive the substantial benefit of his or her bargain and is excused from performance. Here, Karp agreed to construct a garage for Manor for $10,000. Karp stopped performance after only 25% completion, so Manor did not receive a substantial benefit of his bargain. Manor's performance was not due when Karp stopped performance after only 25% completion of the garage. As there were no progress payment clauses in the contract, Manor was not in breach by refusing to make the progress payment, but Karp was in fact in breach by stopping performance. Therefore, only Karp is in breach, and only Karp is liable for Manor's damages, if any. Question number 5. Pate sued Dr. Doak for psychiatric malpractice and called Dr. Will as an expert witness. During Will's direct testimony, Will identified a text as a reliable authority in the field. He seeks to read to the jury passages from this book on which he had relied in forming his opinion on the proper standard of care. The passage is A. Admissible as a basis for his opinion and as substantive evidence of the proper standard of care. B. Admissible as a basis for his opinion, but not as substantive evidence of the proper standard of care. C. Inadmissible because a witness's credibility cannot be supported unless attacked. Or D. Inadmissible because the passage should be received as an exhibit and not read to the jury by the witness. Take 10 seconds. If you chose option A, you'd be correct. It's admissible as a basis for his opinion and as substantive evidence of the proper standard of care. To be admissible, expert testimony must be based on the knowledge, experience, and training of the expert, be beyond the normal experience of an average lay juror, be helpful to the determination of the action based on proven and reliable data and methods, and be an application of such methods and data to the underlying facts of the case. Furthermore, under the learned treatise exception to the hearsay rule, a learned treatise is admissible to prove anything stated in it as long as that book is an accepted authority in the field. In this case, Dr. Will testified as an expert witness and asked to read to the jury passages from a text he identified as a reliable authority in the field, and on which he himself had relied in forming his opinion on the proper standard of care. As such, this passage would be admissible as a basis for his expert opinion as well as substantive evidence of the proper standard of care under the learned treatise exception to the hearsay rule. Question number 6. Dan, an 8-year-old, rode his bicycle down his driveway into a busy highway and driver had to stop her car suddenly to avoid colliding with the bike. Because of the sudden stop, driver's 2-year-old son Peter, who was sitting on the seat without any restraint, was thrown into the dashboard and injured. Had Peter been properly restrained in a baby car seat as required by a state safety statute of which his mother was aware, he would not have been injured. In an action brought on Peter's behalf against Dan's parents to recover for Peter's injuries, Peter will A. Not prevail because parents are not vicariously liable for the negligent acts of their children. B. Not prevail because Peter's injury was attributable to his mother's knowing violation of a safety statute. C. Prevail if Dan's parents knew that he had sometimes driven into the highway and they took no steps to prevent it. Or D. Prevail if Dan's riding into the highway was negligent and the proximate cause of Peter's injuries. Take 10 seconds and choose the best answer. If you chose option C, you'd be correct. Prevail if Dan's parents knew that he sometimes drove into the highway and they took no steps to prevent it. To establish a prima facie case of negligence, the plaintiff must prove duty, breach of that duty, causation, and damages. The duty of care is a legal duty requiring the defendant to act according to a certain standard to protect the plaintiff against an unreasonable risk of injury. The basic standard of care is that of the reasonable person acting under like circumstances. There is no duty to unforeseeable victims. At common law, parents are not vicariously liable for the torts of their children, unless the parents were negligent in allowing the child to engage in tortious conduct. Here, the determination of Dan's parents' liability for Peter's injuries turns on whether Dan's parents were negligent. The negligence of Dan himself for riding a bike on a highway, or of Peter's mother for failing to secure Peter in his seat in violation of a state safety statute, is a separate issue, outside of the scope of what the question is actually asking. If Dan's parents knew that he sometimes drove into the highway, Peter was a foreseeable victim, so Dan's parents would have owed him a duty of care. Reasonable parents of ordinary prudence in the position of Dan's parents would have taken steps to prevent their child from riding his bike into the highway. Accordingly, Peter will prevail if Dan's parents knew Dan rode his bike into the highway and took no steps to prevent it. Question number 7. Smith asked Jones if he would loan him $500, promising to repay the amount within 2 weeks. Jones loaned him the $500. The next day, Smith took the money to the racetrack and lost all of it betting on horses. He then left town for 6 months. He has not repaid Jones. Smith has committed A. both larceny by trick and obtaining money by false pretenses, although he can only be convicted of one of the offenses. B. Larceny by trick only. C. Obtaining money by false pretenses. Or D. Neither larceny by trick nor obtaining money by false pretenses. Take 10 seconds and choose the best answer now. If you chose option D, you'd be correct. Neither larceny by trick nor obtaining money by false pretenses. Larceny is the wrongful taking and carrying away of another's tangible personal property without consent and with the intent to permanently deprive. The intent to permanently deprive must be present at the time of the taking. False pretenses is defined as obtaining title to another's personal property by an intentional false statement of past or present fact with a specific intent to defraud. In this case, we have nothing to indicate that Smith did not intend to repay Jones within 2 weeks when he borrowed the $500 from him. As such, without the intent to permanently deprive and without the specific intent to defraud, Jones had committed neither larceny by trick nor obtaining money by false pretenses. Question number 8. Under the terms of a written contract, Karp agreed to construct for Manor a garage for $10,000. Nothing was said in the parties' negotiations or in the contract about progress payments during the course of the work. For this question only, assume the following facts. After completing 25% of the garage, strictly according to Manor's specifications, Karp assigned his rights under the contract to Banquo as security for an $8,000 loan. Banquo immediately notified Manor of the assignment. Karp, thereafter, without legal excuse, abandoned the job before it was half complete. Karp subsequently defaulted on the loan from Banquo. Karp has no assets. It will cost Manor at least $8,000 to get the garage finished by another builder. If Banquo sues Manor for $8,000, which of the following will the court likely decide? A. Banquo wins because the Karp Manor contract was in existence and Karp was not in breach when Banquo gave Manor notice of the assignment. B. Banquo wins because Banquo, as a secured creditor over Karp, is entitled to priority over Manor's unsecured claims against Karp. C. Manor wins because his right to recoupment on account of Karp's breach is available against Banquo as Karp's assignee. Or D. Manor wins because his claim against Karp arose prior to Karp's default on his loan from Banquo. Take 10 seconds. If you chose C, you'd be correct. Manor wins because his right to recoupment on account of Karp's breach is available against Banquo as Karp's assignee. An assignment is the transfer of rights or benefits under a pre-existing contract to a third party. The assigner is the party who makes the assignment. The assignee is the party who was not a party to the original contract but is the recipient of the assignment. The obligor is the other party to the original contract who owed performance to the assignor. As per disputes between the assignee and the obligor, an assignee may recover from the obligor directly, but the obligor may assert any defense against the assignee that the obligor could have asserted against the assigner. In this case, the original contract between Karp and Manor to construct the garage for $10,000 was assigned by Karp to Banquo. The question indicates that the Banquo sued Manor for $8,000. So this would be a case of assignee versus obligor. As such, Banquo could recover directly from Manor, but Manor would be able to assert any defenses against Banquo that he could have against Karp. Since Karp unjustifiably breached the agreement and never completed the garage, Manor could assert this defense against Banquo, and for this reason, Manor would win. Question number 9. In a suit by Palmer against Denby, Palmer sought to subpoena an audio tape on which Denby had narrated his version of the dispute for his attorney. Counsel for Denby moves to quash the subpoena on the grounds of privilege. The audio tape is most likely to be subject to the subpoena if A. Denby played the audio tape for his father to get his reactions. B. The lawsuit involved alleged criminal behavior by Denby. C. Denby has been deposed and there is good reason to believe that the audio tape may contain inconsistent statements. Or D. Denby is deceased and thus unavailable to give testimony in person. Take 10 seconds and choose the best answer now. If you chose option A, you'd be correct. Denby played the audio tape for his father to get his reaction. The rule is that any communication between attorney and client or their representatives intended by the client to be confidential and made in an effort to obtain professional legal services is privileged in all criminal and civil proceedings, unless the privilege is waived by the client. The attorney-client privilege may be waived through voluntary disclosure to a third party unless the disclosure to the third party is necessary for the representation. In this case, Denby had narrated his version of the dispute on audio tape for his attorney. Denby then played the audio tape for his father to get his reactions. This disclosure to his father is not necessary to the representation, so this voluntary disclosure would cause the privilege to be waived by Denby and subject the audio tape to the subpoena. And our last question in this grouping, question number 10. While Hill was in her kitchen, she heard the screech of automobile tires. She ran to the window and saw a tricycle flying through the air. The tricycle had been hit by a car driven by Weber, who had been speeding. She also saw a child's body in the grass adjacent to the street. As a result of her shock from this experience, Hill suffered a heart attack. In a claim by Hill against Weber, the issue on which Hill's right to recover will depend is strictly whether A. A person can recover damages based on the defendant's breach of a duty owed to another. B. It is foreseeable that a person may suffer physical harm caused solely by an injury inflicted on another. C. A person can recover damages caused by shock unaccompanied by bodily impact. Or D. A person can recover damages for harm resulting from shock caused solely by another person's peril or injury. Take 10 seconds. If you chose option D, you'd be correct. A person can recover damages for harm resulting from shock caused solely by another person's peril or injury. The rule is that for negligent infliction of emotional distress, the plaintiff must demonstrate that she was in the zone of physical danger that was created by the defendant's negligent conduct. Outside of the zone of danger, a plaintiff can only recover for negligent infliction of emotional distress if the plaintiff was present at the scene, the plaintiff observed or perceived the injury, and the plaintiff and the injured party are closely related. In this case, Hill was in her kitchen and heard the screech of automobile tires. Hill ran to the window and saw a tricycle flying through the air. Hill was out of the zone of danger, so she would only be able to recover for negligent infliction of emotional distress under the theory of bystanders' fear for others' safety. However, the facts do not indicate that Hill is closely related to the child, so Hill's right to recover will depend on whether a person can recover damages for harm resulting from shock caused solely by another's peril or injury. Again, thank you for joining us on Bar 10 Test Prep, where it's our goal to help you prepare for the bar exam 10 questions at a time. Don't forget to like, subscribe, and click the notification bell so you can be updated every time we upload new content. It's our goal to upload new content every day at 8 a.m. Eastern Standard Time.